Welcome to Courtside. Today we are going to review the U.S. Supreme Court's most recent term in about an hour. Here to perform that high-wire act are former NCLA Senior Litigation Counsel Rich Samp, current Senior Litigation Counsel Jacob Huebert, and Staff Attorney Andreia Trifoi, who will discuss her two successful amicus briefs this term. Jacob, let's start with you and the Trump v. Slaughter case, one of the most significant cases of the term. Trump fired FTC Commissioner Rebecca Slaughter without cause. Slaughter sued, arguing that the firing violated the FTC's statutory for-cause removal protections. The Supreme Court held that FTC's provision violates the Constitution and overruled the 1935 case of Humphrey's Executor. Tell us about the Slaughter case. What was at stake here, and did the court get it right by giving the president authority to fire the heads of independent commissions?
Well, as you say, a federal law on the books for many decades said that the president cannot fire an FTC commissioner unless he has sufficient cause. And Trump argued that he didn't need cause because under the Constitution, Congress cannot restrain his ability to terminate people who exercise executive power in the federal government. And that's because Article 2 of the Constitution gives all executive power to the president. And so if he is not able to remove somebody else who's exercising executive power within the federal government, then he doesn't really have all the executive power. He's being forced to share it with somebody else who he doesn't want to share it with. That's one problem. And another thing that he argued was that under Article 2, of course, he has a duty to take care to see that the laws are effectively executed. And he cannot fulfill that responsibility if there's somebody else exercising executive power who he can't control. And of course, if you can't terminate somebody, then you can't really control them. Termination is the ultimate means of control over somebody in this system of government.
I think of it as the insubordinate-subordinate problem.
Exactly. Good. Yes, that's the right way to put it. And so Trump made these arguments, and the Supreme Court accepted them, and rightly so, because, again, for the reasons that he said, the executive power under the Constitution is supposed to be in the president. And if that's not the case, if you have people who can't be held accountable by the president in exercising executive power, well, that means really they're not accountable to anybody. And that is a big threat to liberty when you have people exercising power in the government who we can't hold accountable, the people we elect can't hold accountable. That's a grave threat to liberty. And of course, it's a big problem that has harmed people's liberty in the administrative state that has arisen with these unaccountable independent agencies. And so the court absolutely got it right in siding with President Trump on this. And this is very important to restore the constitutional separation of powers, rein in the administrative state, and in turn constrain officials' ability to infringe on our liberty.
What about the Appointments Clause? It's silent about the removal power, isn't it?
Right. So it's silent about that. So the default is the president has that power as part of his executive power. And
because of the vesting clause?
Yeah, because he has executive power, that is inherent in the powers that he has, unless the Constitution said otherwise. And of course, for appointments, it does. He says he needs the advice and consent of the Senate for principal officers, and there's other options for inferior officers. But where the Constitution doesn't say that, the default is he has this removal power.
One of my favorite things about this case is that Chief Justice Roberts relied on all of the arguments that we had in our amicus brief as to why the president does have this power. But Jacob, what do you say to folks who claim that this puts too much agency power in the hands of the president, now united with legislative power and judicial power that are also in these agencies sometimes?
Well, so the lack of accountability is one problem with the administrative state, but it's not the only problem. The other problem is that these agencies can make law and they can enforce laws against people without people getting all of the protections they should get under our system of government. And it's understandable that people would feel concern if now all of that power that the executive branch has built up is effectively in one person, the president. But the answer to that isn't to continue what we've been doing where we don't enforce the separation of powers? The answer to that is to limit the executive branch to things that the executive branch should be doing, enforcing, carrying out the law, not making law, and not adjudicating disputes between the executive branch and the individual.
Reminds me of a certain slogan: let judges judge, let legislators legislate, and don't let bureaucrats do either.
I like it.
Maybe we'll keep using it. So the other case that was like this, Jacob, was the Trump v. Cook case, something of a companion case to Slaughter. President Trump attempted to fire Federal Reserve Governor Lisa Cook for cause, this time citing mortgage fraud allegations. Cook sued to block her removal. Why did the court say President Trump cannot fire Cook when he could fire Slaughter? And did they get that one right?
Well, he didn't argue in the Cook case that he had this authority under Article 2. Maybe because he wanted to keep the court's attention focused in Slaughter on what's going on there and not bring in the Federal Reserve into it. There, he argued that he had good enough cause because she had committed mortgage fraud, allegedly, before taking office. And she argued that she was entitled to due process. He said, well, she got all the process she was due. And the president also argued there that federal district courts can't issue an injunction to block him from removing someone from office. They might be able to provide some other remedy, but they can't do that. And so those were the issues that the lower courts had ruled on. And here, the Supreme Court said it wasn't going to decide whether there was good enough cause. It was just going to say that she was entitled to some amount of due process. She did not really get any process because the president just announced this in Truth Social and didn't give her a deadline to respond or anything. He just did it. And so they have sent it back on that ground that she did not yet get the process that the court believes she was due. In doing that, it sort of implicitly treated the Fed as different from other agencies, so that the rule under Slaughter wouldn't apply. Because, of course, if the rule in Slaughter did apply, there wouldn't be a right to due process. The president could just remove them. Justice Thomas, in his dissent, pointed out that no, they're not actually different. I mean, they exercise executive power, so there's no reason why we should treat Fed governors differently from others who exercise executive power, which was the argument that we alone made in this case in our amicus brief, and I think that was the correct outcome. Now, the court didn't expressly hold that the Fed is different, so it's theoretically possible they could come back to this sometime and get it right and say that, well, anybody who exercises executive power has to be removable, because otherwise, again, where does that fit into our constitutional system of government? The court didn't really have an explanation for that in Cook. It just kind of acted like, well, the Fed is just different. Historically, banks are different, so it's different.
Will this just come back to the court again if Trump fires Cook one more time after giving more notice and process?
I think there's an excellent chance it'll come back because he will give her presumably some modicum of process, still say his cause is good enough. She'll still say it isn't, and here we'll be again.
Yeah, and that's where the rubber will hit the road, because there were only two justices who voted differently in these two cases. I think it was just Chief Justice Roberts and Justice Kavanaugh. Everybody else voted the same way on both cases, so that'll be interesting to see. Rich, well, first of all, welcome back to NCLA. It's great to have you on site again.
Thank you.
You looked at a case NCLA did not file an amicus brief in, Trump v. Barbara, the Birthright citizenship case. This was a challenge to Trump's January 2025 executive order in which he sought to end automatic birthright citizenship. What did the court hold here, and why does it matter?
Well, first of all, it matters because citizenship is obviously a very important right. For example, you can't vote if you're not a citizen. And if you are a citizen, you can't be deported. And I think it's immigration that was primarily driving the Trump administration in going forward and issuing its executive order. Now, at the end of the day, the court, by a either 5-4 or 6-3 decision, ended up striking down the executive order. And in my mind, they probably reached the right result, but they did so really for the wrong reasons. I would have ruled the way that Justice Kavanaugh did in his concurring opinion. What he said was that basically for the last 100 or so years, the executive branch has acted as though there is birthright citizenship for everybody other than the children of diplomats and a very small number of people like that. Therefore, based on that, it's reasonable to conclude that when Congress adopted a citizenship law in 1940, it probably intended to codify that understanding. And so that was probably the right result. What the majority of the court said, 5 of the justices, was that the citizenship clause of the 14th Amendment provides birthright citizenship to anybody who is born in this country other than the very limited class of children of diplomats, and that applies even to people who are the children of illegal aliens and even to the people who are children of somebody who just sojourned into the country very briefly in order to give birth.
Birth tourism, sometimes they call it.
Sure. And the real nub of the issue is that the 14th Amendment says that a person born here is a citizen, but only if also they are subject to the jurisdiction of the United States at the time of their birth. And that particular phrase has caused quite a bit of controversy. I think there was some substantial arguments that clause was intended to be limited to people who are actually domiciled in the United States, meaning that they were not only physically present, but were here intending to remain here for the indefinite future. And that was what Justice Thomas said in his dissenting opinion. I thought that the constitutional question was both sides argued it very well from an originalist standpoint. It could have gone either way. And in those types of cases, I think it's most appropriate, therefore, for the court to say, we think it's a difficult constitutional question. We don't need to decide it because there is a statutory basis for striking down the EO. And therefore, why don't we do it that way rather than deciding a difficult constitutional issue? But in my mind, really the most striking thing about this whole case is not the actual decision the court ended up with, because after all, it is simply renewing a century-old policy that had been in place until the executive order was issued, but rather really the unfortunate way that much of the news media and legal academics were reporting this issue, because they first of all said, well, this is a really fringe position to be taking the position that was being taken by those who said that there were limitations on birthright citizenship.
Those defending the executive order.
Yeah, and then when there were some very top constitutional scholars, I think in particular of law professor Elin Werman at the University of Minnesota, wrote some very compelling arguments as to why there ought to be some limits on birthright citizenship. Well, the reaction was, well, these people are just so far off the fringe, they ought to be excluded from the academic community for even thinking to express ideas of that sort. And then when the Supreme Court ruled as it did ultimately, the reaction seems to be, well, not that we're happy with the decision, but that, wow, this was such a close call that it just shows you how bankrupt the Supreme Court is, that there are people who would even think to limit birthright citizenship. And really what they're doing is, in my mind, expressing their policy preferences rather than directly dealing with the dissenting opinions in the case. In particular, the dissenting opinions would actually grant citizenship to a very large number of people, that if you are here in this country and have been here for a while, among the dissenters, everybody except for Justice Alito seemed to be agreeing with the fact that you ought to, based on having been here a while, you probably are domiciled here and you ought to be a citizen. They were just saying that the majority got it wrong in their opinion.
Yeah, I wasn't surprised that the court said that a decision of this magnitude couldn't be made by executive order, but I was surprised, or maybe I'll throw it to you as a question. Did the court leave the door open for Congress to try to come back at this, or have they closed the door on that with a constitutional decision here?
I think they pretty much have closed the door. I mean, there may be some attempts to undercut the decision, but when you have 5 votes based on the Constitution, I think that that pretty much is the end of the matter. And I'm not really sure what Congress could do now to stop birth tourism. And that's,
well, they could criminalize it, but that wouldn't keep the person from being a citizen, I
right.
suppose.
And so I suspect that there isn't much that can be done, which is one of the reasons why it is better to have issues like this decided on the basis of a statutory issue.
Right, and by the elected people's representatives in Congress rather than by 9 black-robed justices at the Supreme Court. Andreia, so one of the cases that you wrote a lovely amicus brief in was the Chatrie v. U.S. case. Police had used a geofence warrant directing Google to hand over location data on cell phones near a bank robbery here in Virginia, which was used to help convict him. He argued this violated his Fourth Amendment rights. What did the court say about this, and why does it matter?
Yeah, so the court agreed that partly that when a government uses a geofence warrant, it constitutes a search under the Fourth Amendment. So very, very briefly, I just want to explain how a geofence works. Yeah. So when the government executes a geofence warrant, they essentially draw a virtual perimeter around the scene of a crime. They go over to Google, and they ask Google to turn over the location history of every cell phone user who just happened to be in that perimeter when the crime was taking place.
So lots of innocent people.
Lots of innocent people get swept up in the warrant. And so NCLA was interested in this case because one of the core issues is whether the government can use advanced technology to pervasively monitor people by collecting and storing their location data. And that issue is at the very heart of our challenge against automatic license plate readers, in our case, Schemmel v. City of Marco Island at the 11th Circuit. And so the Supreme Court held in Chatrie that when the government collects cell phone location history through a geofence, it effectuates a Fourth Amendment search, and it needs a warrant to do so. And the court really expanded its prior holding in Carpenter v. United States, and it applied that analytical framework to geofence warrants, and it extended the Carpenter holding beyond long-term tracking through cell site location information to even short-term tracking with...
That was the Carpenter decision, was cell site location information.
Yes.
And this one is information that's stored on an individual cell phone.
Yes, and they work kind of similarly. I think cell phone location history is even more precise than cell site location information, which is kind of ping cell phone towers. So the court really extended its holding in Carpenter. However, it did not actually reach the question of whether a geofence warrant is the permissible warrant. It sent that question back to the Fourth Circuit to answer. But I think the court got the question right in this case. It correctly held that collecting location history is a Fourth Amendment search.
Yeah, I wasn't so surprised by a dissent by Justice Alito here, but I was a little more surprised that Thomas and Barrett were dissenters here. I think of Thomas in particular as more of a civil libertarian. Are they friendly to government invasions of privacy?
I want to give them the benefit of the doubt and say that they're not friendly to government invasions of privacy. I think one of the main problems with this case is that it was a very fractured decision at the Fourth Circuit. It was an en banc court that 7 of them held that there was no search, 7 of them held that the geofence warrant was permissible. And so it was kind of a disagreement. And one of the main criticisms of the dissent was that this case almost functioned like an advisory opinion because it didn't actually help Mr. Chatrie, the defendant in this case. So I'm wondering if they maybe would come to a different conclusion if the circumstances of the case was different. But I do think they are kind of hesitant on expanding Carpenter into an area where it's not all clear how it might apply to other advanced surveillance technologies.
It's an area that's under a lot of tumult right now.
It is, yes.
Yeah. Well, he certainly would have benefited if the court had decided that it wasn't a search. So, or I guess I'm saying that the opposite. If it wasn't a search, he would have been toast, right? So, so he should be thankful that they didn't decide that. But so different case, Jacob, Wolford v. Lopez. This is a challenge by concealed carry permit holders to a Hawaiian law that tried to make it a crime to bring a gun onto private property that's open to the public unless you have, I guess, advance consent from the owner of that property to do so. The folks challenging this said that violated their Second Amendment rights. What did the court say about that, and did they get this case correct?
The court rightly said that it did violate Hawaiian Second Amendment rights. The way this was set up was, yes, you needed to have express permission before coming onto property with a firearm, private property that is. So that meant just going about your day. If you go to the gas station, well, you better have their permission in advance. And the only way you'd get that would be, I guess you could ask, or they could have a sign up saying guns welcome here. But of course, businesses, even if they don't mind you having a gun, probably aren't going to put up a big guns welcome here sign because, well, that requires an expenditure of resources. Some people might find it off-putting. Of course, they're not going to do that. And Hawaii knew that when they enacted this law. After the Supreme Court's Bruin decision a few years ago, they had to let people carry a firearm because the Supreme Court said so. So then they enacted this to make it practically impossible to carry a firearm as you go about your business day to day.
They tried to flip the presumption, essentially.
Exactly, and the Supreme Court recognized that. And of course, they have to justify this by reference to the country's historical traditions around the time of the founding era. And the historical tradition is exactly the reverse of this, because under the common law, you can enter property that's held open to the public unless you are expressly excluded. And they reverse that, and that's not how it ever was. And they can't evade the Second Amendment that way. And Hawaii tried to appeal to its distinct tradition, supposedly, of hating guns. And the Supreme Court said, no, the Second Amendment is the same everywhere. The whole point of the 14th Amendment is that people can have the same rights everywhere, so you don't get to be more restrictive than other states. You don't get to flip this presumption, and the law is struck down.
Will this holding help? I know you have a case pending against Illinois over their firearm owners identification law. Is this holding going to be helpful in that fight?
I think it will, because in Illinois, there's a presumption that you're not entitled to have Second Amendment rights at all unless you go get the government's permission and they decide that you are. That's kind of like what Hawaii's doing, but way worse, because there you need the government's permission before even having a firearm on your own property. And the presumption is that you don't have it until the government says you can. That's not how rights work. Rights mean you get to do the thing without the government's permission. So if what Hawaii did was unconstitutional, which it was, certainly what Illinois is doing should be held unconstitutional as well.
Yeah, it does seem like it'll be analogous in terms of how that comes out. There was another gun case at the court this term, Jacob, where this is the Hemani or U.S. v. Hemani case, where the court looked at the question of whether or not it was okay under federal law, or I guess federal law prohibited owning a firearm if you were a marijuana user. And what did the court say about that federal law, and did they reach the right result in this case?
They did reach the right result in saying that was unconstitutional too. The government tried to justify this by pointing to laws in the founding era that allowed habitual drunkards to be disarmed. But the court, Justice Gorsuch, in his opinion, pointed out some important differences there. One is that being a habitual drunkard that's not a habitual drunkard isn't somebody who uses alcohol sometimes. It's a person basically who's like drunk all the time and is a nuisance to society as a result. And in those times when you had the habitual drunkard laws, someone had to go to court and have that person declared a habitual drunkard before they could be disarmed. There was due process before you were subject to this prohibition. That's not how it is in the federal law. The federal law is, we find out that you're a person who uses marijuana. Oh, you're a person who owns a gun. well, that's it. We can just prosecute you right away. We don't have to have you declared a drug abuser or whatever. And so the Supreme Court said this is not analogous to anything historical. Of course, it violates the right to keep and bear arms for a large group of people. And so it struck that down.
Yeah, a very large group of people use marijuana. So if all of those folks weren't allowed to exercise their Second Amendment rights, that would sweep pretty broadly. Chiles v. Salazar, Rich. This is a case where a licensed Colorado counselor, Kaylee Chiles, challenged a state law, I guess, banning the use of sort of conversion therapy aimed at changing a minor's either their sexual orientation or their gender identity. She said that this law violated her First Amendment free speech rights. What did the court say about that, and why is this case important?
Well, the court held 8-1 in her favor, said yes, it was a violation of her First Amendment rights. And I think this case, it's important, and it shows that the court continues to be very supportive of First Amendment rights, and that's support that really crosses ideological barriers.
Yeah, 8-1, pretty significant.
And one of the things that some states have tried to do in recent years is to say, oh, we're not regulating speech. We're just regulating conduct. And the speech involved here was just incidental to the conduct that they were regulating. And the court would have none of that. What it basically said was the law is specifically aimed at speech. All this counselor did was to speak to patients. And they made clear that this exception for speech that is merely incidental to conduct really has to be that the conduct itself is unlawful. So, for example, if you are engaged in a scheme of fraud, well, to carry out your scheme, you probably have to either say something or write something to another person to try to defraud them. That you can ban speech of that sort. What you can't do, except under very rare circumstances, is to regulate speech, particularly here where you're regulating speech based on the content of the speech. This was not just a time, place, and manner restriction where they can't yell loudly in a residential neighborhood, and that's what's being restricted. Rather, what was being restricted was a precise type of speech, and that content type regulation can only be upheld, the court said, when you have a compelling state interest for doing so. They apply strict scrutiny. So, for example, the type of content-based restrictions that have been upheld include, one is a state is permitted to ban politicking within 50 feet of a polling site based on the idea that might well interfere with the right to vote. But
it's a time, place, and manner restriction, really. I mean, it might be
in a sense. I mean, it's content-based in the sense that you could sell brownies within 50 feet of the polling place. You can't, on the other hand, politic in that area. So it is content-based, but it is only after the court agrees that you have a pretty strong, substantial interest in doing that. Otherwise, content-based restrictions are not permissible. And in this case, there was one argument that the state made that was flatly rejected. And it was first rejected about 4 or 5 years ago by the Supreme Court in a case called NIFLA, having to do with restrictions on abortion advocates, where the court said that there is no exception to the First Amendment with respect to professional speech. Professionals have just as much right as anybody else to speak truthfully, and that if they said the same rule applies here when it comes to people who are counseling with respect to gender or sexual orientation. Now, in this case, it was particularly bad because this was not only content-based restrictions, it was also viewpoint-based. In other words, they permitted counselors to encourage people to experiment and
or to affirm their new identity.
But so only one side of the debate was impermissible, and I think that in particular is what attracted the votes of both Justice Kagan and Justice Sotomayor. They said, well, maybe in some instances we would permit content-based restrictions, so long as you did it even-handedly across the board. But this was clearly not even-handedly across the board. So that the result is that in future cases where you're talking about medical treatment, and for example, a doctor says, well, I would have a First Amendment right to prescribe any drug that I want, I don't think the court would agree with that. I think they would say that if the FDA has found that a particular drug is unsafe, that a doctor nonetheless has the right to prescribe it. But those cases probably will arise in the future. But when it comes solely to advocating and counseling somebody and all you're doing is speech, the court has very firmly come down on the side of the First Amendment.
Well, I've lost track of how many times Colorado has lost a First Amendment case at the Supreme Court, but will they ever learn their lesson, or are they just going to keep providing more opportunities for these 8-to-1
Well, they are still going at it. I mean, when it comes to, for example, what people provide as services for a wedding, and if they don't want to provide them for same-sex marriage weddings, that Colorado still is going after that. So we'll have to wait and see about that.
Yeah, there may be more free speech victories to come for people suing the state of Colorado. Andreia, your other successful amicus brief came in the West Virginia v. B.P.J. case. There was a companion case from Idaho as well, where folks were challenging those states' laws barring transgender girls from participating in women's school sports teams, and these challenges were brought on, I guess, on Title IX grounds and on Equal Protection Clause grounds. What did the court hold in this case, and did it get this decision correct?
Sure. So as you said, the issue here was, do states violate Title IX or the Equal Protection Clause when they designate school sports teams based on biological sex? And the court held no, states don't violate either Title IX or the Equal Protection Clause. So West Virginia was one of these states that restricted participation in women's school sports teams to biological women.
And this was the state legislature that did this?
Yes, the state legislature. And Idaho had a similar law. They reached the Supreme Court and were consolidated.
And why? For safety reasons, for privacy reasons, both, other reasons?
Yeah, the primary purpose of these laws were for safety reasons. Each state made a finding that in sports like football or track, where they're either based on a, well, I guess women aren't playing football, but sports like track, where it's based on kind of physical ability, men and women have different physical abilities. And a lot of the purpose of these statutes really tracked the purpose of Title IX, which was to increase opportunities for women in sports, because prior to Title IX's enactment in 1972, there weren't a lot of opportunities for young women in school sports. And so NCLA was interested in filing an amicus in this case, primarily because of the spending clause. So Title IX was enacted pursuant to Congress's spending clause authority. So,
why does that matter?
So when Congress regulates via conditions on spending, it can essentially regulate the states beyond its enumerated powers, and it can regulate things.
So far, NCLA is working on that. But yes, that's the correct statement of current law. Sorry, please continue.
Purportedly, it can reach. It can reach those areas in which it can't do directly. And the idea is that Congress gives states or its institutions federal funds, and in return, the states promise to carry out some sort of regulation or regulate its conduct pursuant to Congress's it's basically like a contract. So the state accepts the funds, and it can regulate according to Congress's plan. But the Supreme Court has recognized that because it's a contract, the terms of spending clause legislation must be clear. And
you have to know what you're agreeing to up front.
Exactly. You can't, you can't enter into a contract if you don't know exactly what the terms mean. So the idea is that states voluntarily and knowingly accept the conditions that Congress has laid out. And so
So the federal government can't play Darth Vader and say, pray that I don't alter the terms further.
Exactly. And when the state accepts funds, it can't change the terms years later. It has to create a new contract. And so NCLA's amicus brief focused on the spending clause argument, and it said that Title IX, which prohibits discrimination on the basis of sex in educational facilities, means biological sex. No one in 1972 would have understood the term sex to encompass gender identity. And so the Supreme Court held that it agreed with NCLA that Title IX prohibits discrimination on the basis of biological sex and not gender identity. And it also found that these state laws do not violate the Equal Protection Clause. And again, it looked at the purpose of Title IX. It looked at the purpose of these statutes, and it says it does not discriminate on biological sex. They're meant to protect women in sports. And I think the Supreme Court got it right in this case.
Yeah, I was a little surprised. I think it was the Gorsuch concurrence you said that focused on the spending clause issue. The majority didn't. I thought the whole majority might decide the case on that basis because it might have allowed them to escape some of the more contested aspects of the case, but they didn't, and that's fine. Sticking with you on the spending clause for a minute, Andrea, there was another significant spending clause decision from the court this term in Landor v. Louisiana Department of Corrections. And I'm not sure people thought of this as a spending clause case when it first came down. It involves Mr. Landor, a Rastafarian inmate who was forcibly shackled and had his head shaved by prison guards, even though he showed them a piece of paper that was a court ruling protecting his religious right to uncut hair. And so he sued those officials in their individual capacity for damages under RLUPA, the Religious Land Use and Institutionalized Persons Act. What did the court say about his ability to sue these guards in their individual capacity, and what does that mean for the spending clause going forward?
Yeah, so this is an opinion by Justice Gorsuch, who, as you mentioned in the West Virginia case, focused entirely on the spending clause. And the court held that our LUPA does not create a private, it does not allow people to sue correctional officers in their personal capacity.
Why not? And
that's because specifically with this institution, I believe it was a correctional facility in Louisiana, the Justice Gorsuch said that it was the facility itself that accepted the federal funds and so consented to our LUPA's conditions. It wasn't the individual officers. And therefore, Mr. Landor couldn't sue them in their individual capacity.
Yeah. It's interesting because I think of our LUPA as having been passed by Congress in order to make sure that people had the ability to sue to enforce their religious liberty rights, but not necessarily, I suppose, the individual guards as opposed to the corrections facility itself, although I'm sure there would have been 11th Amendment and other issues if they had done that route. So a lot there. Jacob, there was a SEC case, always something NCLA likes to pay attention to. I'm going to pronounce it Sripetch. I don't know if that's correct or not, but Mr. Sripetch allegedly ran penny stock fraud schemes and challenged the SEC's ability to obtain over $4 million in disgorgement, where the SEC had never shown that investors had suffered any pecuniary harm. Did the court uphold the SEC's disgorgement capability in this case, and what's the significance of that holding?
The court did uphold the SEC's power to make people who have violated the securities laws disgorge their supposed ill-gotten gains, even if the SEC couldn't show that anybody suffered any loss as a result of their violation of the securities laws. The court looked to the statute from which the SEC said it got its authority. It said that the remedy provided by the statute is essentially an equitable remedy of disgorgement that the court treated as a long-standing equitable remedy, and said as a result, and the court said, well, that kind of equitable remedy has always been focused on taking away the wrongdoer's gain, not necessarily helping the other party recover for its loss. And because of that, the court said that it doesn't have to prove anything about the loss. It has to just show that the gain was a result of breaking the law. Now, as a matter of statutory interpretation, I don't know if I have a strong opinion on whether that's right or wrong. But I think what is most interesting for our purposes here might be Justice Thomas's concurring opinion, where he does agree with the court about the statutory question, but he points out in that the SEC could do this, but he points out that
he invites further litigation in a sense.
yes,
not,
right.
Not
He
in this
says
case, but
it's not really, he doesn't think it's really like other equitable remedies. He says what they're doing here looks a lot more just like a penalty and something that would be a legal remedy normally. And because of that, Justice Thomas says, it would seem that the Seventh Amendment right to a jury trial should attach here. Because after all, if you're being punished for wrongdoing and you're being made to give up money, well, in any other setting, we would think that that's something you're entitled to a jury trial for. And he says that it seems like that should be the case here too.
yeah, it's
so,
not
yes,
equitable disgorgement if it's based on a statute.
right.
Becomes
They're not
legal
just
disgorgement.
right. It's not just abstract equitable powers. It actually they are looking to the statute. It is functioning as a penalty, and so why shouldn't you have that jury trial right? And so one would hope that the court will take up that issue when someone squarely presents that, so that people facing this kind of enforcement action from the SEC can have their constitutional rights.
Do you think the court got this one right? Do we want the SEC going after people where the wrongdoer hasn't caused any financial harm to anybody?
But I mean, no, I don't like that. What the statutory interpretation, I suppose, is debatable. If Justice Gorsuch and all these others thought it was right, maybe it must be arguable. But it's definitely not a good thing for the government to just go taking money where it can't show that anybody was harmed by what a person has done, and certainly not without giving that person a right to a jury trial.
Rich, there was another case involving one of these federal agencies this past term, the FCC. AT&T and Verizon challenged the FCC's practice of universally issuing, forfeiture orders, fines of a sort against companies without first affording them jury trial rights, arguing that this violated their Seventh Amendment right to a jury. What did the court hold in this case, and did they get this one right?
Well, I guess in a technical sense, they got it right. They did protect jury rights. They said that eventually, at some point in the proceeding, if you're talking about common law legal issues like claims for damages, which are at stake here, that so long as you eventually get a jury trial, it's fine. The problem here was that basically this was a bait and switch by the FCC. They initially suggested that they did have the right to fine people, and then later changed their mind and said, "Oh, you just went about it the wrong way. You paid some money in, and then you appealed. And as far as we're concerned, that was a totally voluntary payment." That doesn't really make a whole lot of sense. And the court, while it defended jury trial rights, also upheld the bait and switch by the FCC. What this case in
$100 million. I mean,
it's a lot of money.
Companies don't usually voluntarily hand over $100 million to the government.
This case involved the FCC bringing administrative charges against AT&T and Verizon, saying that they had not done enough under federal regulations to protect the private consumer data, and that because of that violation, the FCC was proposing to impose a fine. And in fact, they had one of these FCC trials that they do administratively, and they in-house, and they never lose, and there was no jury. And what the law says is that under those circumstances, if you want to appeal from this finding, you can file an appeal to the Court of Appeals. But it was the standard practice at the time that the FCC insisted that you pay the money first and then you sue for a refund. So one of the issues that AT&T and Verizon raised on appeal was we were denied a jury right, and if we go to the Court of Appeals, the Court of Appeals will assume all of the factual findings of the FCC to be correct, and they can really only argue about issues of law, and so that really is a denial of Seventh Amendment rights. when the case eventually got to the Supreme Court, and it got there because this was two different courts of appeals that came up with conflicting rulings.
Right, the Verizon case came out of the Second Circuit, and the AT&T case came out of the Fifth Circuit, and the courts below reached different decisions, and so there was a circuit split here for the Supreme Court to resolve.
Well, once the case got to the Supreme Court, the FCC said, oh, you didn't really have to file this appeal at all. If you had wanted to, you could have totally ignored us, and you could have just simply waited for us to file a suit to collect the money. And if you did that, you would then, in the collection proceedings, have a right to challenge all of the factual findings that we made, and you would have the right to have a jury be the one to make those determinations.
Well, that's a pretty good ruling prospectively, but it doesn't do much for AT&T and Verizon.
Right, and that's what the Supreme Court said. Prospectively, people will have the jury rights. And this is actually a doctrine that was first developed about 4 or 5 years ago in the Jarkissi case, in a case involving the SEC, where NCLA, myself included, were involved in that case, and the Supreme Court, in a dramatic decision, did uphold the right to jury trials, and basically said that, okay, an agency can get an injunction without having to have a jury trial, but if what they want to do is have common law rights like the right to monetary damages, there has to be a jury at some point along the way.
Yeah.
And the Supreme Court upheld that here, and that was good, but they also said that you voluntarily paid this money, you don't have a right to get it back, which seems a little bit odd, because why would Congress have established a statutory procedure allowing for appeals if it did not think that that was the appropriate way to go? So
it beggars belief a little bit, I think.
Yes, yeah. But at least going forward, the court got it right.
Okay. Last but not least for this roundup is the court's decision from several months ago in Learning Resources v. Trump. Regular watchers of Courtside will recall that we covered the tariffs issue extensively ahead of time in a series of interviews. First, we interviewed our client, Simplified CEO Emily Lay. We also interviewed Learning Resources CEO Rick Waldenberg and Alana Ruffman, who is VP of Marketing and Product Development at Hand to Mind, as well as a separate interview with Stephen Johnson, who served as Supreme Court co-counsel for VOS selections in the tariffs case. Andreia, Jacob, Rich, thanks for your expertise. For additional information about any of these cases that we talked about today, please go to NCLA's website at nclalegal.org. The Supreme Court starts up again in October, and we'll be there, so join us courtside.